Well, hello, welcome Duke alumni and friends to this session of the Duke Alumni Forever Learning Institute. I am Tish Futrell, the Director of Academic Engagement on the Lifelong Learning Team in the Alumni Engagement and Development Team. I'm thrilled to have you with us today for Taking AI to Court, Ethics, Policy, and Platforms. This is the fourth and final session in our FLI Computational Thinking series. Today, we're asking what happens when AI enters the legal and ethical spotlight. This session will explore privacy, transparency, and the responsibilities of tech companies in an AI-driven world. We will have time for Q&A at the end, so feel free to drop your questions in the chat as you think of them. You will also be asked to take a brief survey at the end of the session. So to help us explore this fascinating topic, we are joined by my colleagues, David Hoffman and Liz Sparacino. David Hoffman is the Steed Family Professor of the Practice of Cybersecurity Policy at the Sanford School of Public Policy. He is the interim director of Duke's Science and Society Initiative. He recently chaired the Civil Liberties and Privacy Panel for the Directors Advisory Board for the United States National Security Agency. And he currently chairs the board of the Center for Cybersecurity, Policy, and Law. Liz Sparacino joined Duke as a Technology, Policy Research, and Programs Fellow in January 2025 with a focus on platform, accountability, and digital equity. Since joining Duke, her work has been focused on policy and ethical issues at the intersection of AI and music streaming platforms. Liz recently graduated with her master's in bioethic and science technology policy at Duke. Please join me in welcoming David Hoffman and Liz Sparacino to the Forever Learning Institute.
Tish, thank you so much for that kind introduction. I want to say that the most important thing I think about my background for this audience might be that I consider myself to be a triple Dookie, actually. I graduated from Duke's Law School in 1993, came back to teach after spending about 30 years in the private sector, and my older son actually graduated from Duke a couple of years ago. It's been a tremendous pleasure to be back at Duke and to be teaching, particularly in the new role that I have, which is the interim director of the Science and Society Initiative. I see among our attendees here, I see several of my former students. I see several faculty members that have collaborated with from computer science and other departments. One of our huge benefits here at Duke is the focus on interdisciplinary education that we get. And the projects that we're going to be talking about today and the work that we've done have come out of that interdisciplinary focus, particularly the use case study that Liz is going to describe in a little bit came originally from Bass Connections projects that we have been doing, bringing together folks from engineering, computer science, public policy, law, and the different humanities disciplines here at Duke. And so we think that that's a really important way to look at artificial intelligence, how the technology is going to be integrated into other systems and then what the social implications are, and then what should we do in law and policy about that. So we're going to do two parts of this. I'll talk for about 15 more minutes on the global AI regulation ecosystem, and then Liz is going to talk about the case study of what we've done specifically with Spotify and with AI-generated music and our analysis of what's happening on that particular platform. So our learning objectives here is to give you an idea of the different approaches. I've recently spent time doing presentations very similar to this, both in Rio de Janeiro, Brazil, at a Duke event that we did there, and in Riyadh, Saudi Arabia. What I have found is that countries all around the world right now are looking and trying to figure out where should they be with respect to fostering AI development and implementation, and then also governing that. The people are, particularly the regulators, are looking at that and comparing two different approaches: the current approach that we're taking here in the United States and the approach that the European Union has done with their EU AI Act. As part of that, this concept of risk management and applying some risk management concepts and principles that existed prior, that have been applied to privacy issues, have been applied to cybersecurity issues, applying them here in the AI environment, and then trying to determine how can organizations implement that. So we're going to give you an overview of that before we head into the case study. First thing I wanted to note is that we've been doing a lot of work also on trying to have a way to conceptualize what's going on with artificial intelligence. One of the things that individual regulators have been raising with us at the different sessions that we've been doing, and regulators from around the world, is they say, look, we're worried about digital sovereignty. We're worried about whether we can trust these AI systems. We're going to potentially move to developing fully integrated domestic AI solutions within our particular country. I would posit that I think that that's going to be extremely difficult for any more than just a handful of countries in the world to be able to do. To demonstrate that, we participated in a process with the Paladin Capital Group to define what we refer to as the AI tech stack, and then talk about the trustworthiness of the AI stack, particularly with respect to cybersecurity. Paladin Capital Group's one of their co-founders is Mike Steed. I'm the Steed Family Professor of Cybersecurity Policy here at Duke. We collaborate a lot with Mike. His philanthropy and Paladin's philanthropy has formed the foundation for what we've been able to do in cyber policy. And I would point you to this paper, the AI Tech Stack paper, as an excellent way to understand and conceptualize of what's happening in artificial intelligence. And so starting with the data layer and then moving up to include the models that are going to be used or developed from training on that data, the infrastructure, particularly when we're talking about the GPUs that are being used, but also how those are integrated into data centers and the energy that they use, the applications that end up serving to be the things that are going to manage the algorithms and the models, but also serve as the user interfaces for individuals. And then overarching all of that would be the governance layer that is going to apply. This is where I think if we separate each one of these layers, we can ask questions about, do we trust the data? Do we trust the model? Do we trust the infrastructure? Do we trust the applications? And then how would we govern all of that so that people who are providing us with services at the end of the day that have artificial intelligence integrated into them, that we can have an understanding that they are going to be accountable for trusted technology and responsible behavior. This is a problem that's going to take a while to sort out because we hadn't fully sorted this out with a lot of technology before we started moving to AI implementations. So I want to share with you a bit of where we're headed there and how these two divergent paths that the European Union and the US have taken. So at its highest level, the EU AI Act is a risk management framework focused on identifying what are the uses of artificial intelligence systems, and then trying to categorize levels of individual and societal risk, and then to drive specific requirements to those. And those would be standards that would apply for data quality, documentation for implementation, the level of oversight and engagement that a human would have to have in an individual activity that the artificial intelligence system is being used for, and what level of assessments are going to need to be done while a system is being implemented. Was originally conceived by the European Union as an approach to try to say, look, we don't want to inhibit innovation. We still want, particularly for lots of systems that are going to provide value to human beings, if they're minimal risk, we actually don't want to have a obtrusive regulatory structure that it's going to apply to it. But if we're going to reach up to levels of high individual and societal risk, there needs to be a higher level of oversight from the government so that we're protecting citizens in an effective way. So this is a phased rollout with the different obligations coming in at different times, and we're not going to see enforcement of this until 2031. So this is still a process of learning from all of this and providing feedback and understanding how it's going to be implemented. Similar to other pieces of European regulation in the data area, though, it comes with significant consequences, and it comes with the potential for 7% fines of up to 7% of global turnover, which is gross revenue. So you could imagine, for a large company, we're talking about the potential for fines in the billions of dollars. The first time we really saw this in the technology and data area was with the General Data Protection Regulation, which was the privacy regulation that replaced their 9546 directive with direct application of obligations to the individual EU member states. But this increase, that was 4% of global turnover. Now we're talking about 7% of global turnover. There is a recognition in Europe among many of the regulators to say, we need to have the potential for high enough fines so ignoring the regulation isn't just considered to be a cost of doing business. This is their stab at trying to do that. Let's move to the next slide. So I mentioned that this is a scaled approach based on risk management, where we go scale from minimal risk all the way up to unacceptable risk. So unacceptable risk is going to be where you're not going to be allowed to use artificial intelligence systems in areas that would do social scoring, mass surveillance, or manipulation of harmful behavior. Where I think we get to a really interesting space, though, is when we're talking about the categories that would be deemed to be high risk. This is where we're talking about things around education and employment and law enforcement, where you're actually going to be able to, under the EU approach, be able to use artificial intelligence for these systems with a recognition of the tremendous benefits that can come from the use of the technology. But you're going to have significant oversight responsibilities and assessment responsibilities to make sure that that's being done appropriately. And then you can see the different types of implementations that end up in the limited risk or minimal risk area. So once again, a risk management process obligation to make this kind of determination, and then to impose the obligations that apply to that specific category of risk. All right, so this is another look at the high risk area and giving you more of an idea of the kinds of things that occur within the high risk area within the EU. What I think is really important, you'll get a general sense of these from the list that's here, but there is also a catch-all provision in the EU AI Act, which is basically anything that is then further regulated to be something that would be high risk and would fall into this. So they're creating a dynamic situation. We're saying, look, we want to give some ideas for people of exactly what these high risk systems are. And you can see the kinds of things where it would be the collection of very sensitive personal information, things that would impact core capacities and activities of life, like employment and education, and then areas that would have severe consequences for individuals, particularly in the area of migration or law enforcement or the administration of justice. these are clearly the categories of things that people are looking at for as far as trying to identify what a high-risk AI system would be. All right. So what we've seen here in the United States takes a wildly different approach. So largely during the Biden administration, we had an approach to artificial intelligence regulation that was roughly in line with what was going on in Europe, even if it was in a scaled back approach. It was taking a general risk management approach. This was a risk management approach that was basically invented here in the United States during the Obama administration with application to technology, with the creation of the cybersecurity risk management framework and its update, the CSF 2.0, where it was to say, look, in an area of technology that's rapidly developing, we don't want to impose specific technical obligations that are not going to scale with time. There's a recognition that regulation always trails innovation. And so if you put too prescriptive requirements, particularly that impose specific technical solutions, you're always going to be behind innovation. You're never going to be catching up. But if you put process controls in place to say, look, in the development or implementation of technology, if we're asking people to identify at that point in time what are the risks and to put processes in place to potentially mitigate them, that's something that potentially can scale over time. So that was the approach until last January. Now we are taking a different approach. That was considered by the Trump administration to create too big of a risk of chilling investment in the technology, such that we would potentially be, or we being the United States, be at a disadvantage globally with the resulting AI systems, and they would be developed more quickly, be more powerful when developed in other countries. Particularly the concern has been China, and then those AI solutions coming from China, even if they were not allowed to be used here in the United States, if we were to even know that they were being used here in the United States, that they would be used potentially all over the rest of the world because of the difficulty in being able to not have the most advanced solutions that could be driving societal benefits. I think the experience that the US has had with many countries adopting Huawei telecommunications equipment within 5G networks has been instructive here for the Trump administration to say it is incredibly important for the country to develop the most advanced AI solutions as possible. So what you've seen is the use of executive order instead of legislation. For those of you who are not lawyers, who do not follow this closely, really Congress generally has the power to be able to set up frameworks for the executive branch to do regulation, but within the boundaries of what the legislation has created for executive agencies, the president can direct executive agencies to pursue a particular direction. So this is a robust area of law with hundreds of years of history on the power of the executive, of how far things can be taken in a particular direction. These executive orders largely are first getting rid of previous executive orders, but then really trying to streamline executive regulations to enable investment in artificial intelligence and to remove barriers of regulation in many ways. And so you can see the different categories of these that have happened from January through July. Liz, let's go to the next slide. So once again, here you can see a comparison between the two. You have a risk management regulatory approach in the EU with significant means for enforcement to try to drive compliance. And with the US executive orders, what you have is a system that is primarily focused on the goal of increasing investment and promoting American AI leadership. This comes up, this phrase, time and time ago. They even talk about the American AI stack And there's actual provisions in there directing agencies to promote the US AI stack internationally to other countries through export of American products. Two wildly divergent approaches that lots of countries are looking at and trying to determine what approach that they want to take. When I was down in Rio de Janeiro, I found that most countries there are following the European approach. They've been putting together in place AI regulation and or legislation that follows this risk management approach. However, when I was in the Middle East, I think they're looking at this and saying, look, we've got other mechanisms to do protections of our population. We have consumer protection regulation agencies. We have legislation in some countries. What we really want to do is also spur investment. And they're looking at different government structures, particularly through industrial policy, to be able to do that. This is also something we're looking at a lot at Duke. I co-run an organization called the Deep Tech Initiative with Professor Ronnie Chatterjee from the business school, where we're looking at the way public capital is utilized to spur private investment then to create advances in 5 key technologies, artificial intelligence being one of them, and then semiconductors, climate tech, quantum computing, and cybersecurity technology. And so what we see is a tremendous amount of capital flowing in from all over the world, trying to develop the infrastructure and then to be able to create systems to be able to deploy artificial intelligence across entire societies and countries. We're going to continue to see that, and it's playing out in different ways with regulation of following the EUA Act if you're primarily worried about risk, or the US approach if you're primarily worried about trying to get enough investment to be a leader in artificial intelligence. Liz, can we go to the next slide? So I mentioned the NIST cybersecurity framework effort. They've now then the US, while it is also following this risk management or following an investment approach, NIST is following an approach of trying to articulate how to do AI risk management. What's really important is they're taking the same direction that was originally used for cybersecurity to say this is a voluntary framework. This is really the difference. Like, we're going to tell people how they can do risk management, but we're not going to create an obligation on doing that. So it has these 4 key components that are a cycle of being able to do risk management with governance as the overarching measure. And we see this time and time again with NIST's approach, whether it's cybersecurity, whether it's privacy, or whether it is artificial intelligence. So we're also seeing international organizations creating guiding principles. The OECD has been working on this for a long time to provide guidance to its member countries on how to drive transparency, security, and responsibility. And you also see, along with NIST, you see UNESCO actually stepping in really with a focus on how to protect individuals. So they come at these things from a different perspective. The OECD, much more around how to implement these systems. UNESCO, much more on protecting of individuals. All right, so main takeaways, wanted everybody to understand what's the general approach in the European Union, what's the difference here currently in the United States, why are they taking different approaches, really understand the importance of these risk management frameworks and how you would do risk assessment, and understand that we're now talking, particularly within the European Union, about some significant obligations and enforcement potential for AI systems. With that, I'm excited then for you to hear from Liz about this project that we have been working on for about 1.5 years to implement some of this knowledge by looking at a particular case study. Liz, take it away.
Thank you for Professor Hoffman for the great comparative analysis on the EU and the US's approach. I'm also a Duke alum, so really excited to be here with you all. And in our second session today, you will understand the implications of AI on the creative economy, the impact of AI-generated music on both artists and listeners, and understand how the way AI is impacting the music industry and creative economy is a canary in the coal mine for how AI will impact the future of the dignity of work. In the past 1 to 2 years, we've seen all sorts of creative industries wrestling with questions about the implications of AI on their sectors. We've seen lawsuits from journalism companies, strikes and negotiations with the TV and film industry, lawsuits from artists, again, pushback from actors, and most recently, a pretty big payout to book authors. AI is impacting a range of creative sectors, all with their own unique issues, but broadly, the issues kind of fall into some common themes. During the session, we will explore the implications of AI on the music industry by understanding how music is impacting the music economy and being integrated on digital streaming platforms. In session 1 of this series, Professor Hershey set the stage for the basics of large language models and their role in AI. But before we dive into a little bit more about AI-generated music and the issue areas we're talking about, I wanted to make sure we're all on the same page about what we mean when we're talking about AI-generated music and how it works. This, of course, is a very simplified explanation of a very complex process, but it all starts with a human artist who has an idea for a song and writes and records the song, which usually takes weeks to months and requires tens and thousands of dollars for professional musicians. That song is then created and uploaded to a streaming platform like Spotify or Apple Music. In the case of Spotify, they then collect subscription revenues and divide the money based on a percentage of overall streams the artist has, rather than directly paying an artist per stream, which of course is contingent on some conditions like meeting a minimum number of streams. A portion of that money then goes back to the artist after dividends are paid to writers, producers, and other contributors to the recorded song. So now, how does AI-generated music work? Well, first, an AI crawler has to scrape the web and streaming platforms for human-generated music, which is often done without the artist's permission and without compensating the artist. A generative AI model then must train on that data for a long period of time until it can ultimately create AI-generated songs within minutes or seconds after a prompt from a user or bot. These songs are then sent back to streaming platforms. Often they are mass uploaded and put onto different playlist recommendations, which users then listen to, often unknowingly. And then a percentage of the streaming revenue is then diverted from artists to the entity who uploaded the AI-generated songs. So I wanted to show you an example of a company that produces AI-generated music. This is a screenshot from Suno AI's Premiere Plan. Suno AI is a popular AI tool used to create AI-generated music, and you can see for just $15 a month, a user can create up to 2,000 songs, which far surpasses the number of songs a human artist could create in a month, and $15 wouldn't even cover a small portion of a time in a recording studio. While such low cost and ease of accessibility may be open some creative avenues for the lay citizen, the systems that are creating these songs are benefiting from the hard creative labor of artists over the last century, and they're not being compensated for that work. These systems then divert already low revenue-paying systems to the creators and not the artists themselves. And in this case, we believe that stealing is not innovation. So now that we've talked a little bit about AI-generated music, I wanted to know from you all, to your knowledge, have you ever listened to AI-generated music? You can put your answers in the poll. Okay. Great, thanks everyone for chiming in. It's looking about like majority of people believe they have not listened to AI-generated music. Looks like we have about a 2/3 split. I'll give about a few more seconds. Okay, great. So it looks like about 2/3 of people on this call have not believe that they have not listened to AI generated music. But actually, a lot of people have. And while many of you may not, you'll understand later in the presentation that you have probably listened to AI generated music and you're just not aware of it. But AI generated music is reaching broad audiences. In the spring, The Velvet Sundown received just under 1 million listeners in less than a month. The band was facing a lot of online speculation and pressure that it was a AI generated band, and the original cover image of the band was actually mirroring kind of the famous Beatles Abbey Road image. And then in July, just a few months later, the creator of the band revealed to the Rolling Stones that it was a fully AI generated band. In her book, Mood Machine, The Rise of Spotify and the Cost of the Perfect Playlist, Liz Pelly explores how AI-generated music and ghost artists receive so many streams. Spotify's algorithm favors cheap content through inside partnerships with music groups that create music for passive listening playlists, think like chill study vibes. And she writes, Spotify would deliberately manipulate programming to favor content with better margins without making it clear to listeners. It was not simply a matter of trying to draw boundaries around fakeness or realness in music. It was a matter of survival for actual artists and scenes, a matter of musicians actually having the ability to earn a living on one of the main platforms where music is heard. And she says that this system allowed Spotify to favor such content and open the door for generative AI music makers to walk right in. But how have artists responded to all this? Well, in February of this year, over 1,000 artists in the UK released a silent album called Is This What We Want? In protest to the UK's government proposal to allow AI to train on music and other creative works. And we've also seen similar sorts of movements and advocacy efforts from groups like the Artists' Rights Alliance calling to protect human artists from AI. And what does this mean for the creative economy? Well, AI could put up to 24% of music creators' revenue at risk, which would represent an annual loss of around 4 billion euros by 2028. And AI generated music and music streaming is also projected to get about 18% of the total market value as well. And we can see similar trends in other creative communities with unique implications in each sector. For example, in journalism, Google's AI summaries are diverting clicks away from websites because when users search something on Google, they're just reading that first section. Now that you understand a little bit about what's going on with AI and music streaming, we're going to dive into some more specific topics that represent broad themes across technology, policy, and ethics. As we've discussed, copyright has been at the center of a lot of these conversations around AI and the creative sectors. Copyright law in the US and many other countries does not provide clear legal protection for artists' intellectual property. And there's also a general lack of transparency around both AI-generated music in their training data sets and the labeling of the song itself on platforms. This feeds into the next few issues because if there's no transparency around the training sets, artists cannot receive proper remuneration for the models that have been trained on their content. And if the AI-generated songs aren't labeled on platforms, it's hard to be able to actually take down non-consensual AI-generated music that might unknowingly be uploaded to an artist platform. In addition to issues surrounding copyright and IP, our research team has been exploring Spotify's dominance as a platform among the other major music streaming platforms. So the music streaming market is highly dominated by the three major distribution companies, which include Spotify, Apple Music, and YouTube Music. And part of the problem here is that as platforms get larger and more engaged users, they're able to monetize and sell personal data to data brokers and advertisers, as well as listening data to further enhance their recommendation algorithms, which just means users keep coming back to the platform and the market grows more concentrated. tailored recommendation algorithms not only impact users, but also artists because it impacts how they're exposed to different listener and fan bases. As we discussed earlier, Spotify favors cheap content that costs them less royalty, which ultimately impacts artists' ability to make a living and continue to put music that we love and that makes us feel emotions on platforms. Now, you might be asking yourself earlier, I talked about the actors and writers' strikes and the successful negotiations that they have. So, why don't artists strike and negotiate with music streaming platforms for fairer rates and algorithmic transparency? Well, actually, artists can't unionize and organize for fair wages because of a 1984 National Labor Board ruling that classified artists as independent contractors. Fortunately, Congresswoman Deborah Ross from our own North Carolina has proposed the Protect Working Musicians Act, which we've been following really closely here on our team. And this would allow artists to collectively bargain with platforms on the range of issues we've discussed, from AI music policies to payola rates. And we're expecting that the Protect Working Musicians Act will be reintroduced with some Republican co-sponsorship in this coming congressional session. As we discussed briefly in the previous slides, music streaming platforms collect large amounts of data which can be used to monetize the platform and further progress its concentration in the market. Platforms like Spotify are motivated to collect data for a few reasons, but primarily because personal data can be sold to advertisers who can create inferences about users. I think this morning my day list was called something like Fragile Sad Girl Indie Pop Tuesday Morning. And just from that title of my day list alone, you can begin to imagine the kinds of sensitive inferences that platforms like Spotify can make about you from the music, the podcasts, and the audiobooks that you listen to. These inferences can be created into profiling tools like depressed woman in mid-20s or single parent with low income to monetize you as a listener, because at the end of the day, music streaming platforms are businesses, right? And in the US, we don't have a federal comprehensive data privacy law or any sort of sector-specific law that would regulate music streaming platforms. So essentially, a platform can do whatever it wants as long as it falls under the disclosures that they make and a really broad privacy policy. We thought this was a really interesting case study because everyone consumes music and everyone listens to music. And so we wanted to know a little bit more. And so we dug deep into Spotify's privacy policy. And what we found is that Spotify uses really non-exhaustive language, like examples include, may include, and certain partners, so that they don't have to specifically disclose the names and entities of third parties that collect your data. Not only do they not disclose that, but they don't really give a lot of detail about like how your data is actually used and the inferences that can be made. So this means that they can collect really sensitive data that can use to predict things like sexuality, relationship status, diet, and smoking habits. And in deep in Spotify settings, you can actually request some of this information, and it takes about like 2 weeks, but they'll send you a little bit about the data and inferences that they have on you. And then lastly, Spotify's privacy policy does not have any limitations about what data is shared or who it is shared with, and again uses this broad, non-exhaustive language of things like fulfill contractual obligations with third parties, which the normal person has no idea what that means when it comes to their personal data. The last theme to explore is the intersection of AI and music streaming with the protection of children on online platforms. Music streaming platforms host harmful or inappropriate content for children, and parental controls and content filters are often hidden behind paywalls. In addition to that, many parents report that there are insufficient flagging mechanisms for harmful content that they find, which is only being exacerbated by the flooding of AI-generated music and other kinds of media on platforms like Spotify. Luckily, there's a few more protections for children on platforms like COPPA and data retention policies and the safe harbor self-regulation rules. But ultimately, on each different platform, they have different parental control mechanisms, and it makes it hard for parents to navigate all the different kinds of protections for their children across media platforms they're consuming. And a lot of parents also report that it's really easy for a child user to actually just toggle off the parental controls with no notification to the parent, and this is usually a feature that they're paying for as well. We've discussed a range of issues today at the intersection of AI, music streaming, and the creative economy. But why does this really matter? First, without the labeling of AI generated music and proper remuneration for artists, we strip both consumers and creators of choice and limit democracy. Secondly, when AI systems rather than humans create music, we lose the authentic emotional connection and cultural understanding that have historically galvanized communities around shared experiences and social movements. Additionally, we believe our case study of the music industry is the canary in the coal mine for AI's implications on the labor force generally. How we handle the use of artists' work to train generative AI will set the precedent for human creativity, whether human creativity becomes fuel for algorithms that threaten to replace it. And really, this is just the new business model of tech capitalism: train on humans and replace the human workforce to streamline profits. In the first half of this presentation, Professor Hoffman compared the EU and US's approach to AI regulation. And in the second half of this presentation, we looked at a case study of AI and music streaming, exploring how generated music is affecting working musicians and the creative economy. We want to challenge you to reflect on these standards and principles discussed today when asking yourselves, what ethical and legal standards are needed for the future of AI? Thank you for your time and attention, and we look forward to answering some questions.
Well, thank you so much, Liz and David. We do now have some time for questions. So if you have any questions, please put those in the chat, and we've got some time to get those answered. So yes, if you have any questions, please drop them in the chat. I'll go ahead and start with a question for the both of you. And thank you again for such a great presentation. I mean, I'm hearing it's the data. It's all about the data. But how does someone go about fixing, I guess if you would call it their algorithm, so that they're not, seeing things like AI generated music or things like that, for either of you, Liz or David?
Liz, do you want to take that first?
Yeah, sure. That's a really great question, Tift. And unfortunately, there's not a way to fix your algorithm right now because, as we discussed a little bit in the presentation, AI generated songs aren't being labeled on platforms. And a great step and policy recommendation would be to actually allow users to make the choice of whether they want to listen to AI generated music or not. Once that content is labeled, we could imagine a system where, similar to how I think on Spotify, you can click on a playlist and say, I don't want this to impact my recommendations, that I actually don't want to be recommended music that is labeled AI generated music. Spotify actually recently, last week, um, announced that they are going to be creating some kinds of AI protections. They've mentioned some vague labeling ideas. We're not really sure like what exactly that's going to look like, whether that's going to be kind of like the little verified check next to an artist you see, or whether it's something that's going to be hidden in the song credits. So this is really an ongoing issue, and hopefully in the next weeks and few months, as Spotify and other platforms begin to roll out some kind of labeling mechanisms, we might see some ways to actually take some control over your recommendation systems as a user and a listener.
Yeah,
Great.
I just want to add to what Liz has said, that to just say we've been working with a number of artists, including a Grammy-nominated singer, Tift Merritt, from here in North Carolina, who is a visiting scholar at Duke. And what we find is the impact on artists and the significant decreases that they're seeing in their compensation for their music, which is impacted by this flood of artificial intelligence generated music on the platform, is having a significant effect. And the only way we're going to be able to do something about that, I think, is collective action to ask policy stakeholders to put legislation in place to be able to make some changes. And so that's where we're headed with our particular project. And we're going to be making some requests of Congress and have been building some momentum, particularly to create more power for musicians to be able to negotiate in the ways that we've seen screen actors and screenwriters be able to do that to protect themselves.
Great. Thank you so much, David. And that kind of, I think, touched on the very first question. That was, how do you figure out if the music that you're listening to is AI generated? I mean, with the
Yeah,
labeling, of
I'll
course.
take that first, and then let's, this is something that we're actually looking at right now. Artists generally want to be known, right? So if you're hearing some music and you think it's interesting and it has an artist's name attached to it, then if you're doing a search for that artist on the internet and you're not finding anything, that should be a pretty good sign that this might be something that's being generated. Like what we saw, though, with the Velvet Sundown, though, it could be something that's more sophisticated than that. This is unlikely. I think it's an edge case because really with a lot of this artificial intelligence generated music, this is about scale. These platforms are posting thousands and thousands of tracks. They don't have time necessarily to do a lot of web page creation or want to spend the money for hosting that to have it out there. But there's still tells, like when we were looking at the Velvet Sundown this summer, when this first hit the press, and we were saying, you can kind of tell by looking at this, the images aren't exactly right, the story doesn't look exactly right. You go down and try to search for more information about the individual artist, you're not really finding anything. There are ways to tell. So the fact is, it's similar to reading privacy policies in general. Nobody has the time to do this. And until we create a labeling system like what Liz had mentioned, where it's right there for you to understand that this is artificially intelligence generated music, and then you can make your own determination. Do I want to listen to that music, or would I rather listen to music that comes from human beings? That's going to be where we need to move to.
Great. Thank you so much. We have another question here from, it looks like Bijou. Do we need to teach AI ethics to high schoolers and future generations? And if so, how do we do it?
I think we should be teaching ethics in general to high school students and future generations. That's the whole basis of what I do here at Duke, and it's the basis of what we do in the Science and Society Initiative. And so maybe I'll leave a little bit of the how to Liz, because Liz actually graduated from that program.
Yeah, I mean, I think you're absolutely right that we certainly need to be educating students to think about ethics at the forefront of issues rather than something that's just tacked on to the end. And I think as AI is kind of making its way into all sorts of different sectors, like we talked about, we believe this is really just the canary in the coal mine. I think people are getting to start to understand that this is not something that can just be tacked on at the end, and that ethics training and thinking about how technology impacts not just like our current time, but future generations and our future world from a broad range of perspectives is something that we're really going to have to think about how we adjust our education system to change, kind of like reflect what the current issues are affecting our world.
Yeah, and just
Great.
to add just a bit to that, the approach that I generally take here on campus with our students is what we would call an approach of reflective equilibrium, which is this idea of people have gut reactions of what they think is fair and just, what they think is right and wrong. As we apply those gut reactions to individual situations, particularly these new scenarios that are coming up with technology, and we get people in dialogue with each other about why they might be coming to different solutions about them, and then identifying what are their values and where their values come from that cause them to have those different reactions. That's where we get to a place where we really can have robust conversations about What kind of a society do we want? What role do we want technology to play in that society?
Great. Thank you for that, David and Liz. And here's a question I think everyone is probably has at the top of mind, and that is, do companies have to delete your data if you request them to? And also regarding privacy online these days, what are your go-to privacy tools that we all should consider?
Yeah, I mean, the short answer is it depends where you live right now. So if you really want to be able to delete your data, move to California or the European Union. But the thing to really watch underneath that is this recent law that's been passed in California. This is something we're really proud of because it actually came from work at Duke on our data broker project when we convinced John Oliver to do an episode on data brokers. We found out later that the person who proposed the Delete Act in California, which gives the rights to be able to delete this information and obligations to really make sure that entities are doing so, came from that legislator actually watching the John Oliver episode that featured our research. So this is something I think taking a look at that and asking some questions. Should we really make it so that you have to move to California or the European Union to do this? Or what I think is that we could use really in this country comprehensive federal privacy legislation that carries that obligation.
Okay, great. And there was another question regarding the EU, and that is, although they have implemented a more robust regulatory framework, isn't their 2031 implementation date a little too late? And then that kind of segues into another question. I'll just kind of combine those about their approach and, the possibility of it driving our approach to AI in policy.
Liz, do you mind if I start and then add on?
Please.
Did shorthand for this during the presentation. The 2031 date is the eventual date where every single obligation, including a lot of the governance obligations and the need for the European Commission to analyze how well implementation is going, is happening. Most of the obligations are coming on board well before that, and as do the enforcement requirements.
Great. Thank you for that. And it looks like we have time for one more question. So if someone drops that in the chat, then we'll ask that question. But
Ish, maybe Liz and I could both take the question I didn't answer, which was the second part of that, about
okay.
how we feel about the US approach versus the EU approach. Liz, do you want to go first with that? And then I'll give my take.
You can go first.
All right. I think we often get trapped into this false dichotomy within technology, law, and policy, where we think we either have to choose innovation or we have to choose protecting people. I think this is something we should fundamentally reject, and we should say the basis of an educational institution like Duke University should be in getting people together to figure out, how do we do both? How do we make sure that we have controls in place so that people aren't being harmed and companies are deploying things in a responsible way, while still being able to bring technology to bear for the big social problems that we have, trying to improve healthcare, trying to improve transportation and impact on climate. I think we can do those things. I think if we looked at some of the best pieces of what's happening in the EU and the US, we might find the right solutions. Liz, do you want to add anything?
Yeah, no, I really agree with your answer, and I think that we do really put ourselves in these two kinds of boxes, and you see that in a lot of discussions from big tech companies and journalism about AI regulation. And at the end of the day, most of the tech companies that are emerging and becoming most influential in our world are global companies. So we do have to figure out a way to harmonize and balance both innovation and regulation, not just from regional aspects, but from a global perspective. And that's going to really require everyone sitting down at the table, like Professor Hoffman mentioned, and figuring out where there's different harmonies and the different approaches to regulation.
Wonderful. Well, thank you so much, David and Liz, for a great session, and to our audience for joining us today. We look forward to seeing you at the next Forever Learning Institute. Thank you.